Hello everyone, I am Bhavika from Chandigarh Civil Services, and today in this video I will be discussing with you a topic from paper 2 of law optional, that is performance and discharge of contract under the Indian Contract Act of 1872. The subtopics which are to be covered under this include contractual obligations and its exceptions, rescission of contracts, and frustration of contract. Today in this video, firstly I will be giving you an overview of the topic of discharge of contract, and then I'll be discussing doctrine of frustration. In cases of agreements fulfilling the conditions of Section 10 of the Act, which are called contract, there is a duty to perform the contract. When the object of such contract is fulfilled, the liability of the parties under the contract comes to an end and it ceases to bind them, then the such contract is said to be discharged. A contract may be discharged in many ways, and the first is by performance. In performance of contract, there are two ways in which a contract is discharged. First, by performance of the conditions of the contract, and secondly, by an unconditional offer to perform at a reasonable time and place with a reasonable opportunity to the promisee to examine. But if such offer on being given is rejected by the promisee, then the contract is said to be discharged. फॉर एग्जाम्पल मैंने आपको कोई सर्विसेज प्रोवाइड करनी है जिसके लिए आई कॉल यू अप एंड आस्क दैट वेदर आई शुड कम टू परफॉर्म माई सर्विसेज, पर आप मना कर देते हो कि आने की नीड नहीं है, देन द ड्यूटी टू परफॉर्म सच कॉन्ट्रैक्ट इज सेड टू बी डिस्चार्ज्ड. द सेकेंड इज डिस्चार्ज बाय ब्रीच. इसमें जब वो पार्टी टू कॉन्ट्रैक्ट फेल्स और रिफ्यूजेस टू परफॉर्म इट्स ड्यूटी, या वो कुछ ऐसा एक्ट कर देते हैं जिसकी वजह से ड्यूटी परफॉर्म करना ही इम्पॉसिबल हो जाता है, देन इट इज सेड टू बी अ ब्रीच ऑफ कॉन्ट्रैक्ट. इसमें ऑन द ब्रीच ऑफ द अदर पार्टी ऑन द ब्रीच द अदर पार्टी इज डिस्चार्ज्ड फ्रॉम द ऑब्लिगेशन टू परफॉर्म हिज पार्ट and also gets a right to sue. We study this topic separately in detail because it is specifically mentioned in the syllabus by the UPSC. The third method is by frustration, which I'll be discussing later in the video. Another method of discharge is by agreement. अगर parties एक agreement बना लेती हैं according to which they are dispensed with the duty to perform the contract previously entered by them, then as per section 62 and 63 of the Act, the contract is said to be discharged. Lastly, a contract can be discharged by operation of law. The situations like insolvency, death, merger, lapse of time make it impossible for a contract to be discharged. In these cases, the contract terminates by operation of law. Now I come to the topic of frustration of contract, which is also known as doctrine of supervening impossibility. Section 56 of the Indian Contract Act uses the word impossibility. If there is an impossibility which is there from the beginning, then it renders such an agreement void. However, when after the contract has been made, the performance of such a contract becomes impossible or unlawful due to a subsequent event, then the contract automatically dissolves. The concept of supervening impossibility in India includes two things. The first is physical impossibility due to the disappearance of a subject matter. This principle was laid down in the case of Taylor versus Cardwell, also known as the music hall case. इस केस में a person agrees to rent his music hall, पर रेंटिंग से पहले ही म्यूजिक हॉल में आग लग जाती है and it gets destroyed. जब लेसी ब्रीच ऑफ कॉन्ट्रैक्ट के लिए सूट फाइल करता है तो लेसर कहता है कि म्यूजिक हॉल ही डिस्ट्रॉय हो चुका है. So the court in this case held the contract to be discharged when shared contractual assumption has destroyed by change of circumstance. And this case had a huge impact while this provision of the Indian Contract Act was being drafted. The second is where there is no physical impossibility, but the purpose and the object of the contract has broken or has failed to materialize. This is called frustration in English law. There is a case cited as Krell versus Henry, in which the defendant had hired a flat only for the viewing of coronation procession of the king, but the procession got cancelled. The court held that the taking place of the procession was the foundation of the contract, and the object of the contract was frustrated on non-happening of the event. Therefore, the concept of frustration of contract extends also to cases where the performance of the contract is physically impossible, but the object that the parties had in mind has failed to materialize. So, the definition of frustration as laid in Cricklewood Property and Investment Trust Limited versus Leighton's Investment Trust Limited is the occurrence of an intervening event or change of circumstances so fundamental as to be regarded by the law both as striking at the root of the contract and as entirely beyond what was contemplated by the parties when they entered into the contract. Further, there are certain grounds of impossibility which have become well established as to why will the contract frustrate. The first being destruction of the subject matter. This I have already discussed with you the case of Taylor versus Cardwell in relation to it. The second ground is change of circumstances. In this, the change of circumstances must be such as to make the performance of the contract impossible or extremely difficult in the manner and time contemplated, which upsets the purpose of the contract. पर अगर parties हैं जो जब वो कंट्रैक्ट में एंटर कर रही हैं उनको परफॉर्मेंस की डिफिकल्ट कंडीशंस की पूरी नॉलेज है या पार्टीज के व्यू में है कि सर्कमस्टांसेस ऑल्टर हो सकती हैं तो डॉक्ट्रिन ऑफ फ्रस्ट्रेशन अप्लाई नहीं करेगा. The third ground is non-occurrence of the contemplated event, which I have already discussed in the case of Krell versus Henry. The fourth ground is death or incapacity of a party. अगर टर्म्स ऑफ द कॉन्ट्रैक्ट ऐसी हैं कि प्रोमिसर की पर्सनल परफॉर्मेंस रिक्वायर्ड है, then death or incapacity of promiser will put an end to the contract. For example, a person A promises to paint a picture for B for certain sum of money. However, before painting a picture, A dies, so the contract becomes void. Another ground is government or legislative intervention, like if there is a change in any policy or law by the government which has direct impact on the fulfillment of contract because it has transformed the conditions of performance which were thought of. The last ground of being intervention of war or warlike conditions. For example, a person A contracts to take a cargo for person B at a foreign port. The country in which A lives declares war against the country in which that port is situated. So the contract becomes void when the war is declared. Now I come to the last topic of the day, that is exceptions to the doctrine of frustration. The impossibility of performance is a rule and not an excuse for non-performance of contract. Some of the cases where impossibility of performance is not an excuse includes commercial hardship. This is a situation when the performance of contract may be unprofitable or expensive, but it is not sufficient to excuse performance because there is no change in the fundamentally different situation which shall frustrate the contract. Like in the case of Ganga Saran versus Ramcharan Gopal, which is popularly known as the Victoria Mill case. A person enters into a contract to sell cloth of a particular mill, but mill failed to supply the cloth to the seller. But the cloth was available in the black market at higher rates. So in this case, the court held that there is no frustration. The second exception is the non-performance of the contract due to events which are self-induced, that is, which are happening due to the default of the contracting party himself. Thirdly, act of the third person on whose work the promiser relied does not comes under frustration. Further, failure of one of the objects for which contract is entered into does not terminate the entire contract. Lastly, the doctrine of frustration applies only to cases of executory contracts and does not apply to executed contracts. Finally, I come to the last segment of the video. These are some of the questions that have been asked in the previous years related to the topic of frustration, and I think you must try to write these. You can also send the answers for checking to me at my email ID law.bhavikabansal@gmail.com.